This is Carl DeMaio on News Radio 600 KOGO. Coming up at the 4 o'clock hour, should your child be allowed to buy over-the-counter birth control in California? Well, that law is going into effect, and we're going to have both sides on that issue. But first, we are looking at a civil liberties issue versus national security issue. You have the federal government, the FBI, getting a federal magistrate to issue a court order requiring that Apple help the feds open up the cell phone of Saeed Farook. This is the dirtbag terrorist up in San Bernardino. Apparently, they have his cell phone, but they can't get into it because Apple has created such a good cell phone. It's hard to penetrate. So now they've got a court order saying, "Hey, Apple, you're going to have to help us open this thing up." And Apple has said, "No way, no how," and they're trying to fight it. 800-600-KOGO, 800-600-5646. Do you agree with Apple? Should they stand up to the federal government, even if it means compromising potential information that's on that cell phone that could be helpful in fighting the war on terror? Or do you think the feds have a right to snoop around? Now, there's two things that are of interest here. And one of them is, unlike the NSA spying, where everyone was spied on, this is not a court order to force Apple to get into everyone's cell phone. It's to force them to get into one specific cell phone, Saeed Farook's. And so I think a due process has been followed. In our last segment, we had the gentleman say, "Well, it's not your place of it's not your home. You're not your domicile, and that's unlawful search and seizure is in your domicile, right?" Not quite. Fourth Amendment. Here's what it reads: "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall be issued but upon probable cause." Houses, papers, and effects, and persons means that they can't search you. They can't search your house. They can't go through your papers, which I would argue your computer is basically modern day paper, and effects, your purse, your bag, etc. Unreasonable searches and seizures. Now, in this case, they've got a court order because the guy was the terrorist. How do we reconcile this? And is it a slippery slope if we force the Apple Corporation to unlock this cell phone? And then the federal government has access to how to unlock it. Where do we go from here? Let's go to our guest, Wendy Patrick. She's a legal expert. We've had her on multiple times. She's a good friend of the DeMaio Report. Wendy, thanks so much for joining us.
Oh, thanks, Carl, for having me.
So you saw how I kind of laid out the law here. We've got the Fourth Amendment protecting the unlawful search and seizure of persons, houses, papers, and effects. I would argue that a cell phone is a combination of an effect and a paper. But now you have Apple saying it doesn't matter if you got a court order for this one guy. We're not going to help you because we protect the privacy of our customers. Where does the law ultimately come down on this? Apple's going to appeal, but where do you think this is headed?
Well, this, Carl, is a very interesting case. It's a unique case because we're not arguing Fourth Amendment or we're not arguing unlawful search and seizure. Basically, a judge has said, hey, there's probable cause to look at the phone. But the problem is the FBI can't look at the phone because of the software that Apple's created where basically nobody can get in. And worse than that, you've got this 10-strike rule. If you try incorrectly to sign in 10 times in a row, the phone has a self-destruct feature. So the FBI can't run its numbers to try to, get into the phone that way.
I'm sure they've already tried Allah and ISIS and beheaded. So they're running out of options. So they definitely need this technology.
Well, it's the reason it's a case of first impression and it's being very closely watched is it's really pitting digital security against national security. I mean, counterterrorism efforts, we've got to be able to track what criminals are doing and keep citizens safe for future terrorist attacks. And remember, this couple that they're going after, they went to great pains to destroy other evidence, right? They smashed their personal cell phones beyond recognition. They removed the hard drive of their computer. So law enforcement officials want to know what's on this phone. Now, the interesting part about this particular ruling by the court, and the judge herself, by the way, a former federal prosecutor, gave Apple 5 days basically to give a response if it was going to be unreasonably burdensome, which Tim Cook appears to be doing in grand fashion, the CEO of Apple. He's basically said, look, we don't want to create a back door, in effect, because this is something different than leaving an emergency key under the mat. This is creating a master key that'll open all the rest of these doors. But then you've got to weigh that against valid national security interests. And many of Apple's customers, obviously we haven't had time to do a poll, but, common knowledge anecdotally, a lot of people are willing to give up some measure of privacy in order to substantiate and shore up a higher level of national security.
You know what's interesting about this is that the feds apparently went into a courtroom without Apple even being present to argue their side. And now you got this magistrate that's issued this order. Where does this case go from here?
Well, where it goes from here is back into court, is the short answer, because both sides are going to have to litigate this. And Apple's not saying we can't comply with it. They're basically giving an argument why they shouldn't have to comply with it because as their argument goes, all of the customers' data that could possibly be put at risk. And Apple is arguing, court, you don't understand the magnitude or the potential magnitude that this ruling could have. So it's going to just go back and we're going to have more litigation on this. And the reason it's so important is this could be precedent setting for both sides. And you'll notice the other tech companies are kind of taking a backseat, a watch and wait approach. They haven't really backed Apple. They haven't really weighed in one way or another. But you bet that the ruling here is going to impact the way they do business as well. So it's one of these highly watched cases, the result of which is likely going to have far-reaching impact. And the court just wants to make sure that she is weighing appropriately digital security versus national security in order to maybe there's a compromise position out there, but you got to be sure that, we're going to protect our citizens and that should remain paramount. Many of Apple's iPhone users feel the same way. So important decision. Your guess is as good as mine is here, but we're moving forward in the right direction and basically starting this conversation as to can we do both?
And definitely new case law is going to be made with this case. Wendy Patrick, SDSU business ethics professor and famed attorney, thanks so much for joining us.
Thank you for having me.